you knew this issue of Martin Chara was going to come up. Now, in your own view, the way you communicated this decision, is it something you have reflected on?
The way I communicated in that decision, I will communicate the same. And the idea is to also to communicate to the public that whatever is happening, it's not something to shy away from. So that we come with moderate, soft words. One thing I'll tell you is when I write my judgment, I'm not considering what the judge of appeal will say. I'm dealing with the problem as a judicial officer independently, and if another person feels that I use strong words and criticizes me, I'm ready to be criticized. That's why we are judges.
Yes, we are ready to be criticized, but isn't there an obligation on a judge, and you will be the Chief Justice writing judgments, isn't there an obligation to communicate to the public clearly without leaving a situation where somebody who is marginalized feels that you are not giving due attention to the situation? And I'll read for you what you said there. And I'll read for you. You said there, it is important to distinguish between law and morals. It is the law that a child below the age of 18 cannot consent to sex, which is true. Section 8.5 qualifies the provisions of Section 8.1 and 8.4, which penalizes defilement. It can easily be concluded that it is immoral for one to have sex with a child under the age of 18 years. However, where the child under 18 who is protected by the law opts to go into men's houses for sex and then goes home, why should the court conclude that such a person was defiled? In my view, that cannot be defilement. The complainant normally does not complain, but is made to be the complainant because she is 18. My view is that such a behavior is that of an adult and not a child. Children are not meant to enjoy sexual intercourse. Whenever they do, then that becomes the behavior of an adult. Although the public will frown upon an adult who engages in sex with a child, we should not forget the circumstances have changed. Young children engage in sex at a very young age. This is not out of defilement. Conviction of a defiler should be based on actual circumstances and proof that the complainant was indeed defiled. So basically, when a person reads this, they say you as a judge are saying it is okay and a defiler should be left free if a child behaves like an adult, and it is something that should not be discouraged. That is what the complainants are saying.
Everybody will complain, Judge and Commissioner. Sorry to call you Judge. As I've said, everybody has his own interpretation of what you say. I believe I used very polite words, and I was picking from what the complainant said. If you go back, the complainant, I will be very honest, the proceedings before the magistrate court, that complainant said, I went to this man's house to have sex and I go home. That's what that lady said.
Now, of course, that is different from your other decision. There's the decision of you gave the decision, the Council of Imams versus Attorney General. And in that case, you were very, very clear that whatever the cultural, religious, social issues, child marriage is illegal and it cannot be permitted, isn't it? And in fact, you were very firm. There was no equivocation on your part.
And if you will allow me 2-3 minutes, these are two distinct cases. The first case deals with the defilement of a 14-year-old girl with a man that have been together for 3 years. The second one is a deliberate. You get a 16-year-old girl, marry her off and say the Islamic religion allows somebody to be married at that age. So distinctively, if I am to say it's true, because she was 16, She agreed to be married there, because the problem in the second case was these people had been charged in a criminal case, and now they came to me saying the charges should be quashed because this lady was 16 years and she agreed to be married. The parents gave her to get to be married. Can I say that truly at 16-year-old you are not being defiled, you are being married, and the law should encourage that? I can't say that.
Yes.
And that's why I came up and said, you go and face the criminal cases, and it is not possible. The law does not allow that. Turning now to the other one, here we are with the people who are friends, and now it's not a marriage, this is a friendship which has been subsisting for over 3 years. The facts are clear there, and in my mind I was saying, surely I can smell defilement from very far. The moment I read the charge sheet and the evidence of the complainant, I will know this is defilement. But there are those gray areas where you can see, surely, if the law should serve the society in this situation, do we have a defilement? Thank you.
Mm-hmm. Okay, so the problem there is really the issue of communication, and I just wanted you to tell us, in one case, any women, children looking at both cases, how do they perceive the issue that the law protects them in terms of the kind of issues they face today, sexual harassment, sexual exploitation? How is that to be communicated as a judge who knows that this is a very serious issue?
Okay, I'm getting you, Commissioner. Everybody has his own style of writing. I believe maybe somebody else will say, if I was the one, I would have written like this, massage the paragraph, say how did this lady fall into this and that. So to me, as you have said, it was deemed to be the worst. Where was the competition done? It doesn't bother me. Who came next the following year? Why haven't we heard of another one? We have just heard of that. When was it remitted for competition? Who assessed it? So the following year, who took the trophy? So those are things which, as a judge, does not bother me.
Okay.
But communication, you have said, on reflection, I think I did my best to deal with the case at hand. And I can tell you for sure, despite all these hullabaloos, the number of magistrates who have called me to say you have freed us from these shackles of Sexual Offences Act are many.
Will take us back to the Martin Charo case that you already you've been asked about from a different perspective, though. Often when a judicial officer is working or handling a case, you find yourself in a situation where the law kind of conflicts with your personal views or your personal sentiments on the subject at hand. I'm looking at the Martin Charo case. I've read the decision, and one gets the impression that in that judgment you are dealing with several aspects of our sexual offences law that have generated a lot of debate. The age of consent, the minimum sentences, the defense of reasonable belief that the victim is above 18 years old, and even the Romeo and Juliet clauses. And one gets the impression that your sentiments, your personal sentiments, may not be in consonance with what the law provides for. So what I want to hear from you, Judge, is what do you do in scenarios where you find what you believe as a person conflicts with what the law provides for?
Actually, it's not that the judgment is contrary to the law. That would be a narrow interpretation or looking into that judgment. as Commissioner Majanja has said, maybe the hue and cry is maybe the communication. That is another aspect of looking at it. So the several aspects at the age of consent, it's not that I'm advocating for the reduction of the age of consent. In another judgment, I tried to explain, I think even in that one, how other countries have the age of consent, some as low as 14. But the issue is not even the age of consent. The issue is, I'll go back to the question by acting CJ, the social aspect of the law. Is the law serving the people, and how do we interpret it? Because also it's an issue of interpretation. If I were to operate that when the ingredients of defilement, age, the action and identification, and go to prison, I don't think that is the duty of a judge. The issue is you have to analyze what transpired. So the age of consent to me is not an issue, but my issue is also the minimum sentences, because as a judicial officer, having seen an 18-year, until recently, an 18-year-old, a 17-year-old boy with a 17-year-old girl, the boy goes to prison. Until recently, when I think one of the judges said they all could not consent and acquitted them. So this minimum sentence to me is a problem, because it ties the hands of the judicial officers and it is contrary to the aspect of independence of the judiciary, because the judicial officer is the one who is hearing this case. Because compare the Martin Charo, assuming I was wrong and I was to convict, can you compare Martin Charo with somebody who violently pulls a young girl to the bush and defiles? Yet all of them get the same sentence. In the case of Martin Charo, these are people who have been dating. Even they went to the parents' home and slept there for 3 days. Even the brothers knew where their sister was. So can you say because the law provides minimum sentence, everybody should suffer the same fate irrespective of the circumstances of the case? I don't think so.